and then I'll proceed when we ask a question about order when you tell me you're okay.
You're good.
Hey, Executive, Mr. Wayne Gallagher, item number 12 on our agenda is in the building, in the lobby. Would it be acceptable if we proceeded to his item first, or would you rather go in order? And I'm open to what you suggest.
Given that the executive session agenda is not particularly long, I think we should go in order.
That's fine.
But if you want to rearrange, we can.
Fair enough. No, that's exactly what I wanted to ask you, and I decided to do it in public, executive session public, so to speak. Okay, the first item is the executive session consent calendar involving 4 items that have been placed there because the complaints did not include documentation that the mandatory grievance process had been satisfied. First question, colleagues, on items 1 through 4. Are there any colleague, any commissioner want to remove an item from that consent calendar? Hearing and seeing none, Vice Chair, please, a motion on the consent calendar for the executive session.
I move the commission approve the executive session consent calendar as presented.
Thank you. Any questions, comments? Administrator will call the roll, please, on the executive session consent calendar items 1 through 4.
Commissioner McCulley.
Aye.
Commissioner Burke.
Aye.
Commissioner Payne.
Aye.
Commissioner Resendez Gutierrez.
Aye.
Commissioner Mettler.
Aye.
Commissioner Jancy.
Aye.
Commissioner Mason.
Aye.
Chair Fiscom.
Aye.
Motion passed 8-0.
Thank you, colleagues. We will now move on the executive session calendar agenda to items 5 through 9. These 5 cases have been, quote, consolidated, unquote. Am I right, Investigator Gallagher?
You're correct, Chair.
So that is a new term that is different than the former term we used that said they have all waived confidentiality. They have been consolidated. So they're appearing, several of them are appearing, 2 of them are appearing with us, Mr. Ramsey and Ms. Heather. Am I right?
They're supposed to be. We haven't been able to get them on the line yet.
Okay,
So,
let's just pause for a few seconds and see if they join. And then we'll consider these items in terms of the reports and the commentary all together before we vote individually. Is that acceptable? Thank you. The individuals, Mr. Ramsey and Ms. Heather, were intending to appear via Teams. Am I right?
correct.
Thank you.
And Ramsey was just going to be listening, but I do think Laura was planning on saying something, or at least potentially, yes.
Okay.
We are calling them really quick to see.
Yeah,
if
please.
they-
We'll
yes.
give you just a couple seconds for that to occur. And Mr. Ramsey is listening only to indicate that, and Ms. Heather may speak depending on how it goes. Thank you.
Chair Fiscom,
Please.
can I just, Vice Chair Payne, I just sent you an email only because I wanted to clarify what language you could use for the motion on these cases, that you don't have to do each subsection. Save you some words.
And the vice chair is now smiling. The record should reflect. Progress.
It looks like one of the respondents is having trouble joining. So,
We'll stay on hold, folks, for a moment or two.
Are you double checking the number?
yeah,
This one is, the conference ID is 876-523-750. That's the conference ID. You get in.
Yeah.
It's weird because it does have, if you look at the wrong thing.
yeah. Okay, just one moment of silence while we let her in. This is Heather is joining us.
So is Laura Heather is online now?
Okay.
Yeah, that's fine.
Okay, respondent Laura is in the room. She is joining from a telephone. So she is muted right now.
Is this, her name is Laura Heather, last name Heather,
First name Heather, last.
first name Laura? Thank you. Ms. Laura, are you on? Can you hear me? Ms. Laura, can you acknowledge just for a moment to make sure you can hear me and we can hear you?
You can press *6 to unmute if you're on your phone.
Just to repeat,
Yes.
if you're on your phone, press *6.
I can hear you. I just can't figure out the technology.
No problem.
Okay. But my last name is Lara. My first name is Heather.
Thank you very much, Ms. Lara. Thank you for being here. For the record, my name is Dave Fiscum. I'm the chair of the commission, and the time is now to hear items pertaining to the Oregon Trail Academy. Our approach has been out, as you probably by now know, is to hear a report first from our investigator on that'll apply to the 5 individuals consolidated involved with the Oregon Trail Academy, including you, as well as, just for the record, Shannon Chisholm, Mark Ramsey, Amy Curtis, Katrina Ramsey Muir, if I'm saying that right, and you. After that,
Correct.
we may have questions for our investigator. Then we'll give you a chance to make any comment you choose to make to us and proceed. That said,
I
Investigator
don't have
Gallagher,
any
please.
comments.
That's fine. We'll ask you that when the time arrives. Investigator Gallagher, please proceed.
Yes, thank you, Chair Fiscum and commissioners. This is Investigator Lyon Gallagher for the record. Executive session agenda items 5 through 9 in your meeting books are preliminary review reports for the members of the School Board of Oregon Trail Academy, or OTA. This case involves multiple allegations. Based on the information reviewed, it appears some may be violations and others may not be. It appears that the school board may have violated the following provisions in public meetings law. The notice provisions in ORS 192.640 subsection 1 and OAR 199-050-0040 with regards to the April 8th, 2025 school board meeting. Based on the information reviewed, it appears the agenda for this meeting was posted only through a privately accessible app called Parent Square, requiring prior registration and approval. Well, it does appear that the notice through Parent Square may have been made available to parents, students, and teachers, as well as a group of community members previously registered on the community thread group. No information was presented to indicate that any notice was made to the general public. Further, it appears the agenda was posted in Parent Square the day before the meeting on April 7th, which is less than the required 48-hour minimum notice. Also, it appears that the notice lacked the required information for the public to request an interpreter or communication aids. Additionally, OAR 199-050-0070 sub 3 outlines that the required grievance procedure. It appears that the school board may have failed to satisfy the requirement to post on its website the person and contact information to whom a public meetings law grievance may be submitted. Based on the information reviewed, other matters alleged in the complaint do not appear to violate the public meetings law. The complaint alleged the agenda for April 8th meeting lacks sufficient specificity. However, the agenda appears to include a list of principal subjects. And while additional items appear to have been added during the meeting, public meetings law allows governing bodies the flexibility to make changes to an agenda up to and even during a meeting. Also, the complaint alleged meeting minutes were not available within a reasonable time after the meeting. It appears, however, the meeting minutes were provided within 10 days of the request. Please note that in the report, we mistakenly said that this was a violation, and it was not a violation. We apologize for any confusion and want to confirm that it does appear not to be a violation of ORS 192.650 subsection 1. With respect to the allegations that the school board failed to post video recordings of its meetings to its website, this requirement was added in 2024 by Senate Bill 1502, which specified that it applied to governing bodies of a common or union high school district. The 2025 legislative session, Senate Bill 1109 passed, which amended Senate Bill 1502 to specify that the requirement applies not to all governing bodies, but to the board of directors of a common or union high school district. The OTA school board is not the board of directors of a common or union high school district. Rather, it's the school board of a charter school within a common or union high school district. Even though Senate Bill 1109 was not in effect on April 8th, the day relevant to the OTA school board meeting, the specificity of the bill's language could be read as an indication of legislative intent that the provision of the original Senate Bill 1502 only applies to school districts of board of directors and not to the OTA charter school board. Given that, although the report indicates this could be a violation, upon further consideration at this point, we recommend the commission dismiss this alleged violation. In summary, there does not appear to be a substantial objective basis to believe the OTA school board violated ORS 192.650 sub 1 or Senate Bill 1502. There does appear to be a substantial objective basis to believe that the OTA school board may have violated ORS 192.640 sub 1, OAR 199-050-0040, and OAR 199-050-0070 sub 3.
Investigator, for the clarity and precision of that report, I, for one, appreciate it. Any questions for our investigator based on what she has just reported to us? I have a question. Is it appropriate for me to ask whether you would be able to summarize for us any information that you received after your deadline from Oregon Trail Academy personnel? I believe there's a couple of communications. Am I right?
There are.
I know you could not consider those as part of your report based on deadlines, but I don't have a copy yet. Can you summarize those in some way, shape, or form for us?
Yeah, we received 3 responses, Chair. They didn't add any new information based on the facts. They do express frustration with the process. There is a second case that will be before you with the same body. And so
At a later meeting.
yes.
Thank you.
And you just discussed something around intent. This is a board that is trying to meet things that were complained or grieved to them. And so that might be relevant to this discussion, but no new facts. So I wouldn't suggest we consider those. It's
Thank
just
you.
the appeal.
Appreciate the response. Colleagues, any further questions for our investigator? Okay, Ms. Laura, I heard that you indicate you did not plan to say anything, but I want to give you one more chance. If you care to speak to us about the issues involving your case, this is your time to do so. So can you just confirm that you would prefer not to speak?
Yes, that's correct.
Thank you for your attendance today. We appreciate your participation in this. Colleagues, the time is now for us to consider what's before us and decide how to proceed. And again, just for the record, even though these have been consolidated, to use a new term of art, which I appreciate, we will consider these items in one by one, if that's five. So this relates to how we should proceed in general on these issues, and then we'll when we vote, we'll do it one by one. Any suggestions about how to proceed or comments based on what you've heard? Okay, hearing and seeing none, Vice Chair, I'll take a motion on item number 5 involving Shannon Chisholm.
Thank you, Chair. I move that the commission find there is a substantial objective basis for believing that Shannon Chisholm may have violated ORS 192.640 subsection 1, OAR 199-050-0040, and OAR 199-050-0070, and that the commission should investigate accordingly.
Thank you, Vice Chair. You've heard the motion. Any questions, colleagues? Hearing and seeing none, the administrator will call the roll. Item number 5 on our executive session agenda. Proceed.
Commissioner Burke,
Aye.
Commissioner Payne,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Chair Fiscom.
Aye.
Motion pass 8-0.
Moving on to item number 6. Vice Chair, please.
I move the commission find there is a substantial objective basis for believing that Mark Ramsey may have violated ORS 192-640 subsection 1, OAR 199-050-0040, and OAR 199-050-0070, and the commission should investigate accordingly.
Heard the motion, colleagues. Seeing and hearing no questions, the administrator will call the roll. Item number 6.
Commissioner Payne,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Chair Fiscom.
Aye.
Motion pass 8-0.
Moving to item number 7. Vice Chair, please.
I move the commission find there is a substantial objective basis for believing that Amy Curtis may have violated ORS 192-640 subsection 1, OAR 199-050-0040, and OAR 199-050-0070, and that the commission should investigate accordingly.
Heard the motion. Seeing no questions, the administrator will call the roll, please. Item 7.
Commissioner Mason,
Aye.
Commissioner Payne,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Chair Fiscom.
Aye.
Motion pass 8-0.
Okay, moving on to item number 8. Vice Chair, please.
I move the commission find there is a substantial objective basis for believing that Katrina Ramsey Muir may have violated ORS 192-640 subsection 1, OAR 199-050-0040, and OAR 199-050-0070, and the commission should investigate accordingly.
You've heard the motion, no questions. Minister will call the roll. Item 8.
Commissioner Jancy,
Aye.
Commissioner Mason,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Payne,
Aye.
Chair Fiscum.
Aye.
Motion passed 8-0.
Thank you, colleagues. Moving on, item 9. Vice Chair, please.
I move the commission find there is a substantial objective basis for believing that Heather Lara may have violated ORS 192-640 subsection 1, OAR 199-050-0040, and OAR 199-050-0070, and the commission should investigate accordingly.
Thank you. Seeing no questions, the Administrator will call the roll. Item 9.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Payne,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Chair Fiscum.
Aye.
Motion passed 8-0.
You, Ms. Heather, Miss Laura, Miss Heather, pardon me, Laura Heather, I apologize. Ms. Heather, thank you for being with us today. Please understand the comment I make to many people, many of those who appeared before us in such matters. We have not found there to have been a violation yet. We have only identified the need for more information. Our staff will be in touch with you to proceed, you and your colleagues on the Oregon Trail Academy. So thank you for your attendance with us this morning. Have a nice weekend. Okay, you can exit her from our process, and we'll move to item number 10 involving Representative Gregory Smith. And as soon as the exit has been occurred, which the thumbs up says it has, we'll now move, colleagues, item number 10 involving Representative Gregory Smith. The investigator is Casey Fenstermaker. Please proceed with your report. Mr. Smith is not appearing with us today. Am I right?
Correct.
Thank you.
Good morning, Chair Fiscum. I'm Casey Fenstermaker. Agenda item number 10 is a preliminary review report for State Representative Gregory Smith. As a state representative, Gregory Smith is required to file a statement of economic interest each year. The complaint in this case alleged that Representative Smith failed to disclose that Morrow Development Corporation, referred to as MDC, was a client of his business, Gregory Smith and Company. Beginning in 2024, SEI filers are required to disclose clients that constitute 10% or more of their business's gross annual income and have a legislative or administrative interest, or has been doing business or could reasonably be expected to do business with the government agency in which the public official holds office. Representative Smith confirmed that MDC does in fact contribute 10% or more to the gross annual income of his business. The question then is whether Morrow Development Corporation has a legislative or administrative interest in the Oregon legislature. Legislative or administrative interest is defined to include economic interest distinct from that of the general public in any matter subject to the decision or vote of the public official acting in their official capacity. Based on the fact that Gregory Smith is a state legislator and that Morrow Development Corporation is an entity that is registered to do business and that actually does business in the state of Oregon, MDC does in fact appear to have a legislative or administrative interest in the Oregon legislature. It should be noted that in response to the complaint, Representative Smith advised that they reached out to OGEC this year regarding MDC and whether or not that business would have a legislative or economic interest and whether or not it needed to be reported on the SEI. I believe that I took that call. The call included a couple of different topics related to the SEI filing, and I cannot recall whether or not it was MDC specifically that they inquired about, but I do know that they asked about legislative or administrative interest, and based on that discussion, we determined that there wasn't one. However, still due to the failure to disclose Morrow Development Corporation on both his 2024 and 2025 SCI, there's a substantial objective basis to believe that Representative Smith failed to report a client that constitutes 10% or more of his business's income and has a legislative or administrative interest.
Investigator, any questions for our investigator based on the report you've just heard? Happy to acknowledge any question that any of you have. Any of you has? I think it's has, right? Has? Singular. Whatever. Any questions? Hearing and seeing none, since Mr. Smith is not appearing, time is now for us to decide how to proceed on this matter. Any comments or suggestions on that? Hearing and seeing none for the moment, we'll move to the motion on this from Vice Chair Payne, please, on item number 10.
I move the commission find there is a substantial objective basis for believing that Gregory Smith may have violated ORS 244-060 subsection 9A, and the commission should investigate accordingly.
Thank you, Vice Chair. You've heard the motion. Any questions? Hearing and seeing none, the administrator will call the roll on item 10, please.
Commissioner Jancy,
Aye.
Commissioner Mason,
Hold on just a second, Matt.
What happened?
Go ahead, Molly.
Commissioner
sorry.
McCauley,
Aye.
Commissioner Burke,
Aye.
Thank you.
Commissioner Payne,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Chair Fiscom.
Aye.
Should we wait for Commissioner Mason or no?
Oh, what's the vote?
Well, I said aye.
Thank you.
When
Mr.
Burke
Mason
was
says aye.
talking.
No problem.
Thank you.
Okay.
Motion passed 8-0.
Thank you very much. Colleagues, my proposal is the following. We will consider one more item, and then as we'll just recess for a moment to allow our individual who's on site to come in. We'll take advantage of that moment for a bio break, then we'll proceed through the rest of the agenda. So we'll now move to item 11 involving Vance Lump from the city of Astoria. And my understanding is that Mr. Lump intends to appear via Teams.
Yes.
So I will wait till you are ready.
30 seconds. We did get a hold of him. He said he's joining right now, so we're
No
just
problem.
waiting for him to appear in the lobby.
We'll just pause for a second till Mr. Vance is online. Pardon me, Mr. Lump is online. I'll get this down pretty soon. Mr. Lump is still trying to join. Pause for a few more moments.
It is showing Vance, but a different last name. So are you okay if I let him in and we just confirm?
Sure,
Oh,
please.
Say McDermott.
yep, yes. Okay, perfect. Then he is.
Just a
being let
different
in the
name.
room.
That's McDermott.
Thank God.
No win.
Okay, he is in the room and has mic and camera capabilities.
Okay, I believe there's a gentleman online whose last name either is Mr. Lump or Mr. McDermott. Can you confirm that you can hear me? Vance McDermott, I see your face. Can you hear me?
Yes, I can hear you. I don't know why
Thank
it says
you.
McDermott. That's my old legal name.
That's fine.
Yes, that's me.
We'll take your word for it. My name is Dave Fiscum. For the record, I'm the chair of the commission. Our process is now going forward in a moment to hear the report on the case involving you. Our first step is to hear from our investigator, Ms. Fenstermaker. Please proceed.
Sure. Thank you, Chair Fiscum. Commissioners, I'm Casey Fenstermaker. Agenda item number 11 is a preliminary review report for Vance Lump, City Councilor for the City of Astoria. The complaint alleged that Councilor Lump failed to announce a conflict of interest during discussions of an ordinance regarding vacation rentals. The conflict allegedly arose because Councilor Lump is the vice president of the Astoria Housing Alliance. During the preliminary review, I should say, it was determined that the Astoria Housing Alliance is not a business as defined in Oregon government ethics law, and therefore not a business with which Vance Lump is associated. And therefore, he was not required to declare a conflict of interest. The recommendation, therefore, is to dismiss this complaint.
Investigator, any questions for our investigator based on the report you've just heard, colleagues? Hearing and seeing none. Mr. Lump, if I'm saying your name right, if you'd rather have Mr. McDermott, I'm pleased to choose your name. Use your name of choice. This is your time to make any comments to us you choose to make on this matter, on the matter before us. Please proceed if you like to say anything.
Just that I agreed with the report. I don't get any remuneration from the Astoria Housing Alliance, and so there's no financial benefit to me. And so that's all I got.
Thank you, sir, for joining us today. We appreciate it. Colleagues, any questions for the gentleman appearing before us? Hearing and seeing none. You ready to discuss how to proceed? Hearing and seeing no hands, we will now have a motion from our vice chair. Please proceed, Vice Chair Payne, on item number 11.
For the executive session agenda item 11, I move the commission dismiss the complaint against Vance Lump.
Thank you. You've heard the motion. Hearing and seeing no hands raised, the administrator will call the roll. Item 11.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Payne,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Chair Fiscum.
Aye.
Motion passed 7-0 with one abstention.
Thank you. Mr. Lump, this matter has now been dismissed, so thank you for your appearance today. We appreciate your patience with our agenda and have a nice weekend. Thank you.
Yeah, you too.
Okay, colleagues, as I said, we're now going to recess for at most 5 minutes for a bio break while we get set for the next installment. Mr. Wayne Gallagher and our investigator, Mr. Sullivan, will be coming in. We're now in quick recess. Thank you. Ready?
Mhm.
Thank you, colleagues, for your patience. I now hereby reconvene the executive session meeting of the Oregon Government Ethics Commission under the previous rules and statutory authority as stated on August 8th, 2025. The next item on our agenda is item number 12, better numbers, item 25-319, involving Mr. Wayne Gallagher, the superintendent of the Coos County School District. Mr. Gallagher has traveled here to be in person with us from a far distance. Thank you for being here, Mr. Gallagher. Our process on such matters as this is to hear first from our investigator, after which we have questions for him, and then we'll allow you to make a statement to us. We appreciate your attendance today. That said, the first step is Mr. Sullivan's report. Please proceed, Mr. Sullivan.
Yes, thank you, Chair Fiscum and Commission. This is Investigator Josh Sullivan for the record. I'm presenting executive session agenda item number 12. This is a complaint against Wayne Gallagher, Superintendent for the Coos County School District 8. The complaint in this case states that Wayne Gallagher committed nepotism when he used his position as superintendent for the district to hire his wife, Marcy Gallagher, as the district's food service supervisor. The information in this preliminary review indicates that Wayne Gallagher was not involved in the hiring process, which was handled by the district's human resources director. However, it does appear that Wayne Gallagher signed and approved Marcy Gallagher's employment contract and signing bonus. Because it does not appear that Wayne Gallagher disclosed his conflict of interest to his appointing authority in writing, it appears that he may have violated the conflict of interest provisions of government ethics law. And by signing his wife's contract to employ her with the district, it appears that Wayne Gallagher may have also violated the nepotism provisions of government ethics law. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that Wayne Gallagher may have violated the conflict of interest and nepotism provisions of Oregon government ethics law, and the recommendation is to move this case to investigation.
Thank you, Mr. Sullivan. Any questions for our investigator based on the report you've just heard, colleagues? Hearing and seeing none from commissioners online, as well as not seeing my own hand raised. Mr. Gallagher, thank you for your appearance today. This is your time to make any comments you choose to make to us. Please identify yourself for the record and proceed. Thank you for being here.
My name is Wayne Gallagher. I'm the superintendent of the Coquille School District, Coos County number 8. Yes, I do want to address that, and I do appreciate Josh getting me his preliminary findings of his review. And I will say that I also appreciate the fact that he did, in his preliminary review, state that he did uphold that I did not violate use of my public official office or my position based on his findings. So dealing with the first one, conflict of interest. I do have a letter here from our board chair. There is, I don't know if any of you are familiar with the town of Coquille. It's less than 5,000 people. There's 2 stoplights. It's on 42 on the way to the coast. Very small community. There is no way that any of our board members did not know prior to their voting that Marcy was my wife. My wife was actually hired in the Coquille School District prior to myself. She was hired in 2012. She was the previous food service director. She actually, at one point, the district had a partnership with the North Bend School District, and they ran our food service program for us. This became financially challenging for our district because of some lack of management by North Bend. And so the Coquille School District decided to take back over food service. So literally Marcy started this program, built this program, and expanded it, again, all prior to me becoming superintendent. Because of some health issues that she had, she decided to retire and be a stay-at-home grandma. She did that for 3 years. During that time, there were a couple of moments that she did step in and help the Coquille School District. One of those moments, our food service director that we hired, Val Bergstead, who was Marcy's previous secretary, had an emergency surgery and needed to be out for a short amount of time, and Marcy stepped in and helped during that time. Again, that was not arranged by myself. That was arranged by our HR director, Rachel Price. So when that violation, as far as the conflict of interest, did I officially fill out and write something down in a written form and hand it to my board? I will be honest, I did not. But I can look each of you in the eye and say that every one of my board members, when they made that vote on that July meeting, Marcy is the only hire on the agenda, clearly knew that they were hiring my wife as a food service director who had previously held that position. And quite frankly, after that board meeting, several of the board members were extremely excited, and they went up to Marcy and said, "We are so glad that you are willing to come back and help us in food service, because this was a huge need." Val, because again of some health reasons, she resigned and gave the district a very short amount of time to have to find somebody. There was an impartial hiring process. Marcy, even though she had the previous position, did have to go through a full interview process with not only our Human Resources Director, Rachel Price, but there were also several building administrators that were part of that panel. And clearly in Coquille, we try not to do anything small. We try to do everything as large as possible. So we not only do food service for just Coquille, we actually run 3 federal programs out of our food service program. We run National School Lunch Program, which provides breakfast and lunch. We also run a CACFP program, which allows us to feed our daycare students as well as our students in the afternoon. All of this is ran through the community eligibility provision, which means that all the kids eat for free. And we also do a summer meal program where we provide summer meals for Coquille, Myrtle Point, and for the Powers School District, which is about 30 miles away. Running 3 different federal programs is an enormous amount of paperwork, an enormous amount of training required that goes into that. If any of you are familiar with the food service programs and the requirements to be a food service director, Marcy does have all of those requirements, the training, and has a bachelor's degree. And again, in the town of Coquille, those are a very rare skill set, and to be able to find someone with her talent and ability, again, I find that to be, the board was again thrilled to be able to hire her. Here's actually a letter. I'm not sure if I can submit that, but it is from our board chair stating that to the best of her knowledge, all of our board members during that July meeting clearly knew that Marcy was my wife. We have lived in the Coquille community. She started working in 2012. I started working in 2013. We actually relocated to the community of Coquille from Camas Valley. Previously, I was the superintendent in the Camas Valley School District, and Marcy had to commute by herself. We relocated and have lived in the community for 7 years and have been extremely involved in lots of different community activities. At one point, I had 2 sons that lived in the community. Daughter-in-laws, grandchildren attend the school district. So again, for even community members not to know that Marcy Gallagher is my wife is not realistic. So based on what I read in the preliminary report on page 5, line 14 says Wayne Gallagher required to provide written notification of his conflict of interest to his appointing authority. However, it appears he did not do so. By failing to disclose his conflict of interest to his appointing authority, Wayne Gallagher may have violated ORS 244120. Again, I will fully admit that I did not put something in writing, but to say that my school board did not fully know and was aware when they made that vote that Marcy Gallagher was my wife, in this circumstance and situation, I can't accept that to be true. They knew exactly what they were doing, and I was not part of the hiring process. And then the next violation of nepotism, which is page 6, line 16, by signing his wife's contract to employ his wife without previously disclosing the conflict of interest to the board, it appears that Wayne Gallagher violated ORS 2441771A. And again, yes, I did sign my wife's contract. As per board policy, as a superintendent, I am the clerk of the board, and I did sign, but I did not sign her contract until after the board chair, Melinda Millett, was there. She reviewed the contract. The board clearly approved a admin confidential salary schedule. She was placed on that salary schedule by Rachel Price based on her experience, and that was what the contract had said. And that's where she was placed. Melinda signed it, Marcy signed it, and then I signed it, yes, in my official capacity as the clerk of the board as per our board policy. If there has been a violation, I want to assure the board it was not on anything, any intent on my part or my wife's part. We have spent an enormous amount of our careers. I've put a third of my career into the Coquille School District, and I'm very proud of the Coquille School District and what we've been able to accomplish, what we're able to offer kids every day in our community and for an employee. And I would like to point out the complaint, and I'm hopeful that all of you had a chance to read the complaint, because this is a very disgruntled employee that timed this complaint perfectly to coincide with an investigation that was ongoing on himself. This complaint came in June. Marcy was hired the previous July. Clearly, if this was a community outreach, community upset, the community would have came forward in September, October, November. No, this complaint came in on June 5th. The person that wrote this complaint, first off, within the complaint, there's multiple errors. He has not worked for the district for 20 years. He was hired in 2020, and he's never been the union president. So either he's purposely being misleading or somebody else typed this and he put his name on it. That's very interesting on how all of that came together. But by him submitting this on June 5th, the investigation that was done by his supervisor and our HR director, Rachel Price, by him turning this in, the only person based on our contract that can do anything as far as his dismissal from the Coquille School District by our CBA or our collective bargaining agreement is the superintendent. By him turning this in, it put the district directly in a position where we ultimately weren't able to take any action against him for his violations found within his investigation, because clearly we did not want to be perceived as the superintendent retaliating against somebody who had made a formal complaint. This individual has also made 2 OSHA complaints and a bully complaint against the district. Do you have any questions for me? I realize.
Thank you, Mr. Gallagher, including for your travel to here, as well as for your comments. Colleagues, now's the time to ask any questions of Mr. Gallagher that might have crossed your mind as you heard him speaking. Looking for hands indicating a question that anybody has. Anybody? Time is now for us to, based on what you've heard from our investigator as well as our respondent, how you'd like to proceed today. I'm happy to hear any comments from colleagues about your desires. I'll just tell you that based on what I've read and heard today, I'm going to use a phrase that our vice chair has used and questioned from time to time. This strikes me as at best a quote technical violation, unquote, my word, as opposed to anything more substantial than that. And I know a violation is a violation. An alleged violation is an alleged violation regardless of its size. I understand that. I also would say that this is an example of a case where I would like as a commissioner to have the ability to direct sending a letter of education based on this review as opposed to moving into an investigation before we can send such a letter. For the record, I wanted to say that, so I'll feel better having said that. Thank you very much. Colleagues, any other comments? I'd be inclined to dismiss, frankly, in light of the character of what we've heard, the technical violation, as well as the responsibility of any superintendent in that community who signs off on actions taken by others, as well as the reference to, and I know where it is, a small community in Oregon with all that implies with regard to how government and school districts operate. Colleagues, comments? Agreements, disagreements with where I'm sending, where I have said I'm inclined to head today? Director, please argue with me.
I want to argue with you.
I figured you did.
I want to make kind of 2 points. One, I understand you're calling it a technical violation, but the language in the conflict of interest disclosure statute for an employee is very clear. You must submit a written notice to your appointing authority so that that appointing authority can then either assign someone else to do the matter or tell you how it would like you to handle the matter. The tell you how to handle it may simply be telling you, we're okay with this. Thank you for submitting the notice. You can go ahead and sign. Once you submit that written notice, you have satisfied your obligation under the statute. There have been many cases before the commission where people say, I didn't do it because everybody knows. That is most likely absolutely true. And I empathize that all of the board members undoubtedly knew she was your wife. It's a small community. But the commission in the past has still held, even though everyone knows, even though what you were doing was a ministerial matter that the board wanted you to do, it would still violate the statute because there was not a written notice. That's what I wanted to.
Thank you, Director. Appreciate it. Vice Chair, please. Save me.
Yeah, no, I thank you, Chair. I do disagree with your sort of analysis on this and sort of lean towards what Executive Director Myers was saying. I sort of see 2 separate things happening here. 1, whether there is a violation, and 2, whether there harm occurred. And sometimes it's sort of like, well, if there's no harm, there's no foul. And I sort of disagree with that approach. I think that goes towards the ultimate penalty. And I agree with you that a letter of education would probably be the result here. But I do think that, simply because everyone knew, and maybe there was no harm done here by the lack of declaring a conflict, I do think we have to be careful in that there's no exception in the rules or in the statute for declaring a conflict simply because people are already aware of the relationship. And so I'm inclined to move forward with an investigation here, even though it may simply lead to a letter of education, because I don't think there's an exception in our rules or statutes for you don't have to declare a conflict simply because people already know a conflict exists. I think it's important that people follow our rules and statutes and go through the process. And whether harm exists or not is something that I think really goes towards the penalty matrix and not whether a violation happened. And so I think we need to be consistent in applying our statutes and rules and then looking at harm in the penalty phase. And I do think a letter of education is appropriate here and probably will be the likely outcome, but I do think we need to move this to investigation. So that's where I would lean.
Thank you, Vice Chair, for your comments as well as the precision of them. That's helpful for me as one observer, participant. Colleagues, any comments on where we ought to be heading and on what the Vice Chair and or the Chair have said? Commissioner McCauley, please.
Thanks. Thank you, Chair Fiscum. No, I just want to support what Vice Chair Payne said. She put very eloquently into words what was in my head. So along with her, I would support moving this forward.
Hey, Commissioner, appreciate your comment. Any other comments, colleagues? Okay, for the moment, hearing and seeing none, the time is now to proceed to a motion before us. I will ask the Vice Chair to make one.
Thank you, Chair. I'll move that the commission find there is a substantial objective basis for believing that Wayne Gallagher may have violated ORS 244.177 subsection 1 and ORS 244.120 subsection 1C, and that the commission should investigate accordingly.
Thank you, Vice Chair. Colleagues, you've heard the motion. Any questions about it? Hearing and seeing none, the administrator will call the roll on item 12 on our executive session agenda.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Payne,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mason,
Aye.
Chair Fiscum.
Aye.
Motion passed 8-0.
Thank you. Mr. Gallagher, again, please accept our appreciation for your appearance today as well as your travel to get here. Please understand that this action does not indicate, this is a very important distinction, does not indicate that the commission has found there to have been a violation. We have simply indicated our need for more information, which means we now move under our statute to an investigation, the likely result of which will be a letter of education to you. I don't want to presume that till it happens, but Mr. Sullivan will be in touch with you as well as when you leave today, as well as from here on. And thank you very much for your participation today. We take your travel, your time here and your travel as an indication that you think this is a serious issue and worth your time. So thank you for being here.
Thank you. And yes, we'll look forward to working with you, Josh.
Thank you. Safe travels. Okay, colleagues, let's move forward to item 13 on our executive session calendar involving Robert Miles. My indication is that Mr. Miles and counsel Ethan Knight intend to appear via Teams.
Yep, so Ethan Knight will be appearing via Teams, and then Rob is appearing via phone, so he will just need a few seconds while everything turns on.
And we're going to just hold for a second because this is an item involving Mr. Sullivan's participation, and he is now coming back in the room. So when Mr. Miles and or Mr. Knight are here, we can proceed.
Okay, both are in the room.
Okay, Mr. Miles and Mr. Knight, can you hear me?
Hello, this is Robert Miles. I can hear you.
Hi, it's Ethan Knight. I can hear you as well.
Thank you very much. For the record, my name is Dave Fiscum. I'm the chair of the commission. Thank you for your patience with our agenda today. The time has now come for us to consider our item number 13, also labeled as 25-338, involving Mr. Robert Miles, former city councilor for the city of Maupin. Our process, as you may understand, involves a report first from our investigator. So we'll hear that report, then we'll proceed in accordance with what you already know to be our process today, heading toward a decision. So that said, Mr. Sullivan, please proceed.
Yes, thank you, Chair Fiscum and Commission. This is Investigator Josh Sullivan for the record. I'm presenting executive session agenda item number 13. This is a complaint against Robert Miles, former city councilor for the city of Maupin. The complaint in this case states that Robert Miles used his official position as a city councilor to facilitate a zoning change that allowed him to pursue private development on residential lots and build an RV park in the city of Maupin. The information in preliminary review indicates that when the city council considered zoning use changes and the approval of a city ordinance 317, which modified the allowed uses of commercial properties, Robert Miles declared a potential conflict of interest. However, because he owned property, commercially zoned property, it appears that he was met with an actual conflict of interest by participating in the discussion and of the zoning uses that would have a financial benefit to himself or his business. Robert Miles also participated in discussions, recommendations, and voted to approve City Ordinance 330, which changed the zoning designation for 3 of his properties. And because it appears that the new zoning designation would result in a change in value to the properties he owned, it appears that Robert Miles was met with an actual conflict of interest. It does not appear that he publicly announced his actual conflicts of interest when he participated in the discussion and approval of City Ordinance 30 or Ordinance 317. And because he took actions to create an opportunity to financially benefit himself and his business that would not otherwise be available, it appears that Robert Miles may have engaged in a prohibited use of office. Robert Miles submitted Statement of Economic Interest reports for 2022 through 2024, and he included his business on sections 1 and 2. However, his reports were missing his business information in section 7. It also appears he may have failed to list additional business information on his 2024 SEI. After the preliminary review was complete, Robert Miles worked with commission staff to update and submit complete SEI reports for years 2022 through 2024. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that Robert Miles may have violated the conflict of interest, prohibited use of office, and SEI provisions of Oregon government ethics law, and the recommendation is to move this case to investigation.
Investigator, any questions for our investigator on the matter before us, colleagues? For the moment, hearing and seeing none, Mr. Miles and/or Mr. Knight, this is your time to make any comments you choose to make to us. I will allow you to proceed. If you both choose to speak in any order, please identify yourself for the record and make comments to us at your discretion.
Thank you so much. Ethan Knight, appearing on behalf of Mr. Miles, thank you so much for the opportunity to speak. I do understand this is at the preliminary stage, and so we've only got a few minutes here to underscore some key points we want to make as the commission makes a decision. And really 3 things I want to touch on. I know you have the report that Investigator Sullivan has gone over, and we think there are a couple of facts really to pull out of that report and that I can offer in addition to the report that get us to the point where we don't think there is cause to go forward at this time with the full investigation. And I think looking at the report, it's probably a close call, but I think in context, when you look at everything, we don't think there's enough to go forward. So if you'll just allow me to touch on those few points. Commissioners, I think this is a case where you do not have an individual trying to trade on their position for financial gain. There's no evidence that this was done intentionally when we talk about the vote on Ordinance 330 here in a moment. And no evidence, of course, that Mr. Miles directly benefited financially in any way from this. So I think that's important context to keep in mind when we sort of look at the actions before the commission. And so those 3 points I just briefly want to underscore as the commission begins to look at Mr. Miles' case. I think the first is when we look at the 2 ordinances in question, and the disclosures attendant to those. We're talking about Ordinance 317 that was in front of the Maupin City Council and Ordinance 330. Yeah, I'd like to note that Mr. Miles did actually declare a conflict with Ordinance 317. And I think that's important in this case because it shows his intent and awareness of his obligations. He declared that. And then when we get to 330, which I know Investigator Sullivan just discussed with the commission, any failure to disclose, I think, in that was inadvertent at best. There's an important piece of that report I want to draw your attention to, and that's from the city of Maupin. And that explains that the rezoning in question in Ordinance 330 was not needed by Mr. Miles. In other words, he did not need for that to pass to go ahead with the development in the space that he had an economic interest in. It was already zoned residential at that point. And that's important because, of course, he's not trading on anything specific with Ordinance 330 for his benefit. So I want and hope the commission will keep that in mind. I think the second point, and this is in addition to the report the commission has in front of it, of course, are the updated SCIs. Investigator Sullivan just mentioned this to the commission, but Mr. Miles, when confronted with the fact that the paperwork was sloppy on the SCIs, the older ones, immediately revised them and provided them to the commission, including Section 7. So, you know, this speaks to what I've been talking about. There was no ill intent on Mr. Miles' part to trade on his public position or to deceive anyone. He immediately updated those and has been forthright, I think, in that process. And I think lastly, and just if the commission would keep this in mind when it decides at this point in time whether to go forward and whether or not there really is cause to go forward, I just encourage the commission to look at the context of the complaint, Mr. Miles' former position, and if there's been any financial gain. The complaint itself, if you look at it, had a number of factual inaccuracies about whether or not he would benefit directly from that vote on the rezoning that were rebuffed directly, factually by Mr. Miles, and then also by Ms. Walsh from the city of Maupin. And I think that matters because I think, frankly, the motivation for the complaint, understandable in some circumstances, is you have a developer in a small town and people don't always like what developers do in small towns. And that's understandable, but it shouldn't be the basis of an ethics complaint like this. And so I just want to draw attention to that. And I know we've only got a few minutes, but in light of all those factors, those three things, we encourage the commission to take a step back and determine at this point in time that there is not cause to proceed with a full investigation against Mr. Miles. I know I've gone over the 3 minutes that are allotted, but if there are any questions, please let me know.
Thank you, Mr. Knight. Does your client wish to speak today?
I don't think Mr. Miles has anything in addition to add. I'll let him weigh in if he does.
No, I was going to add, this is Robert Miles. I would agree with everything that Ethan said there, Mr. Knight, and commissioners. I appreciate your time this morning. Thank you.
Thank you both for appearing before us. Colleagues, now is the time to ask any questions of Mr. Knight and or Mr. Miles that cross your mind. Hearing and seeing it, for the moment at least, none. The time is now for us to decide how to proceed on this matter, the matter before us. I'm open to suggestions. Seeing any hands raised from colleagues online today. Vice Chair, please.
Yes, I'm going to take a cue from a question that Chair Fiscom often asks. Investigator, if this moves to investigation, what additional information would you be gathering?
Yes, so this is Josh Sullivan for the record. The preliminary review looked at those meetings in question where there was the conflict of interest and whether they were potential and actual and what was stated during those meetings. And so the information there that we've gathered in preliminary review is the information that we really need for the investigation. There's not a whole lot more information to gather as far as we have those minutes and recordings and everything. If this moves to investigation, it's something that we'd probably reach out to Mr. Miles and see if he's interested in resolving with the stipulated final order. But yeah, that's my answer.
Executive, any amplification?
Yes.
Comments? Proceed.
I did want to sort of point out one thing, which was something Investigator Sullivan and Casey and I had discussed in depth, which is at the time of the vote. I mean, I understand Mr. Knight saying that he didn't receive, he was already allowed to develop the property the way that he ended up developing the property. But the question in terms of, do you need to disclose an actual conflict, is at that moment, is the decision that's being taken, let's rezone this so that it can be developed residential as it currently is or commercial, could or would that decision result in a financial gain or detriment? And changing the zoning of a property to allow it to be developed commercially, even if he never does that, the change in the zoning has the financial impact, meaning the value of the property is different when it is under zoning that allows either residential or commercial versus only residential.
Chair, may I ask a follow-up question?
Yes, please.
And is that also for the prohibited use of office? It's creating that opportunity to change the property from residential to commercial as well?
Yes.
Okay.
Thank you, Vice Chair and Director. Any other questions for anybody involved in these proceedings before we move toward a decision? Okay, hearing and seeing none for the moment. Vice Chair, you prepared to make a motion while you're on mute? Thank you.
I am. Thank you. I move the commission find there is a substantial objective basis for believing that Robert Miles may have violated ORS 244040 subsection 1, ORS 244060 subsection 8, and ORS 244120 subsection 2B, and that the commission should investigate accordingly.
Heard the motion, colleagues. Any questions about it? Tempted to ask a question of our director rather than Mr. Sullivan, though both, if we are to proceed along the lines of this motion, is the likely result of the process a letter of education, or is it fair for me to state that because that involves a process not yet undertaken?
I mean, we would run it through the existing penalty matrix, and I mean, I think it is likely that it would be a letter of education, but I have to see what the numbers come up with.
I was hesitant to ask that question because it presumes facts not yet in evidence, which you have to go through a process if the vote is affirmative in this regard. But I think that sort of characterizes what we sometimes say about such issues as this. I'll stop. Colleagues, any other questions, comments? Hearing and seeing none, the administrator will call the roll on item 13. Please proceed.
Commissioner Burke,
Aye.
Commissioner Payne,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Chair Fiscom.
Aye.
Motion passed 8-0.
Mr. Knight, Mr. Miles, thank you for being with us today and for your comments. We appreciate them. Understand the following, which is a comment I make to many who've appeared before us. We have not found there to have been a violation at this point. We have only identified the need for more information. We'll proceed by talking directly with you. Thank you for your participation today. We wish you well and have a nice weekend. Thank you.
Thank you so much, and we look forward to working with the commission. Thank you.
Thank you. Okay, colleagues, we'll now move to item number 14. No, we'll time that move to item 14.